10 key aspects for asset purchase agreements. An asset purchase agreement is a contractual document between the purchaser and the vendor that sets out the legal terms and conditions of the transaction of purchase and sale of specific assets of a corporation or business. The following represents 10 key aspects of consideration with respect to asset purchase agreements. 1. Define the purchase assets. Clearly identifies which assets are being acquired and transferred to the purchaser. This can include tangible assets like machinery, equipment, inventory, real estate, vehicles, and intangible assets like intellectual property, customer lists, goodwill, software, brand names, contracts. 2. Exclude unwanted assets. Explicitly lists any assets that are not being purchased and will remain with the vendor. 3. Specify assumed liabilities. Details any specific liabilities the purchaser agrees to take on, such as certain accounts payable, existing contracts. Crucially, all other liabilities typically remain with the vendor. 4. Establish purchase price and payment terms. Outlines the total purchase price, how it will be paid, such as lump sum, installments, financing, and any adjustments, such as based on inventory levels at closing. 5. Allocate purchase price. For tax purposes, the purchase price is often allocated among the various assets being acquired. This allocation can have significant tax implications for both the purchaser and the vendor. 6. Set out representations and warranties. These are statements of fact made by both the vendor and the purchaser about their respective legal standing, the condition of the assets, the absence of undisclosed liabilities, and other material aspects of the transaction. If these statements prove to be false, the aggrieved party may have a claim for damages. 7. Establish covenants. These are promises made by the parties to do or not do certain things before and after the closing of the transaction, such as the vendor maintaining business operations until closing, the purchaser agreeing to keep certain information confidential. 8. Outline closing conditions. Specifies conditions that must be met before the transaction can be finalized, such as obtaining third-party consents for contract assignments, regulatory approvals, satisfactory completion of due diligence. 9. Provide indemnification. Crucial clauses that outline how one party will compensate the other for loss or damages arising from breaches of the agreement, such as false representations, undisclosed liabilities. 10. Address transition matters. Covers aspects like employment transfers, transitional service agreements, where the vendor might provide services to the purchaser for a period after closing, and the handling of shared assets or communications. For experienced legal representation with respect to asset purchase agreements and business transactions, contact our law firm to schedule a confidential initial consultation. Thank you.